What's up, veterans, transitioning service members? Today I'm going live and I'm going to be talking about what is the presumption of soundness in VA disability. I hope that your Thanksgiving was good. Today is November 29th. Thank you for tuning in. We want you to know that you matter, that you care, and just that we care about you, and that there are big things in store for 2025, but we want to keep you up to date with everything that is going on within the VA. There are big changes coming in 2025, so we want to make sure that you are aware of that. And let's get right into it. So, what is the presumption of soundness, right? Based on 38 CFR, right? It assumes all veterans were in good health prior or upon entering service unless specific conditions are documented in entrance exams, right? So, when you go to MEPS, when you do all your exams and all that stuff, they presume that you were good and that you're in good health upon entering service, right? So the next thing that we're going to discuss is the VA's burden of proof, right? If a condition arises or worsens during service, the VA must provide what we call clear and unmistakable evidence to refute this presumption, proving the condition pre-existed and was not aggravated by service. Okay, the burden of proof lies on the VA. They got to prove, if you're claiming that something happened, you hurt your ankle, your back, or something of that nature, then the VA must have a burden of proof to rebuttal that. They must say, hey, no, this did not happen. But if you have the proof to it, then 38 CFR says that you need that the side in the favor goes with the veteran. Okay, but if you do not complain, if you do not get treatment, if you do not get the help that you need, then, and you say, I'm just going to suck it up and deal with it, then how are you going to have any proof? The VA is just going to presume. They're just going to say, hey, this guy or gal, this service member did not complain. There's nothing in the records, and we are not going to grant service connection, right? It's kind of like you getting into an accident, right? And you not having that accident report. So how are you ever going to prove that condition? How are you ever going to prove that happened? How are you ever going to prove that accident happened? Okay. Application and disability claims. The presumption is especially valuable in complex cases, right? For example, like PTSD that appear during service are presumed service connected unless conclusively proven otherwise. And there's protection for veterans, right? Presumption places the evidentiary burden on the VA, not the veteran, ensuring fair consideration in disability claims by requiring the VA to establish undeniable proof before denying service connection. Okay. So the presumption of soundness or sound doctrine is a legal standard applied by the Department of Veterans Affairs in disability claims. This principle is grounded and rooted in 38 CFR Code of Federal Regulations and detailed in 3.304B, right? It states that every veteran is presumed to have entered military service in good health, except for any conditions that were noted at the time of their entrance exam. If a condition develops or worsens during service, or something happens to you in service, it is generally assumed to be service connected unless the VA can provide clear and unmistakable evidence that the condition existed prior to service and was not aggravated by service. Okay. So again, what do you need to connect to get service connection? In service treatment, stressor, diagnosis. What happened? Was it clinically diagnosed? And can I prove that? Right? You got to, as long as you can establish those three things right there, unless you have a lot of time, like let's say you got out in 2015 and it's 2024 going on 2025, you've got almost 10 years of space, and they're 9 to 10 years, and you aren't getting any updated treatment on that back, then you may get denied because there's no continuity of care. The VA wants to know right now, as of 2024, what kind of care are you getting? What kind of treatment are you getting? What kind of medical records do you have? That's very, very important. So I want to key in a little bit on application and aggravation cases, right? If a pre-existing condition is documented at enlistment, any worsening of this condition during service invokes the presumption of aggravation. So here the VA must prove that the worsening was solely due to the natural progression of the condition, not because of service factors. So you can fight that, right? But you need proof. you need an injury that happened in service. You need medical documentation proving that. Let's say you go in and you sprained your right ankle and you let the military know that upon MEPS and upon your entry medical exam. Well, you get in and then you're ruck marching and you twist your ankle even further, say a time or two, and you go back and you say, and you have clear evidence in your active duty medical records or an LOD that says veteran so and so was rucking and they twisted their ankle, and this further aggravated their ankle injury, right? So yes, it started before service, but that in service incident did not help it any. It aggravated it. Okay, so that is what we call the application and aggravation cases. If you go into the military and already have a back or ankle condition, I'm just giving an example, then you know, if you can prove that something further aggravated that in service, that ankle condition, then you need to have that proof. You need to continue to get care and you need to prove that the military caused it to get worse. And then you should be able to establish service connection. If they still want to give you a hard time, then it behooves you to get a nexus letter, a link linking the service connection together or establishing service connection, right? Saying that this incident has absolutely aggravated. It's highly likely. It's more likely than not, in fact, highly likely that this incident that occurred to the ankle has aggravated this ankle condition. Let's go into practical impact for veterans. Veterans do not need to provide initial evidence of good health upon entering service, as this is assumed under the presumption. If they accept you in, then we are presuming that you are in good health. If a condition is not noted at the time of entry, it is generally presumed to be connected to service unless the VA can fully rebuttal this presumption. Okay, so that's very important to know. And then the burden of proof, the VA bears the responsibility of proving that a pre-existing condition and demonstrating that it was not aggravated by service. This is a high standard, meaning the evidence must be undebatable, showing with certainty that the service did not impact the condition. So how does the presumption of soundness apply to you? When looking at a claim, when a VSR is adjudicating a claim, the VA follows specific steps laid out in the M21-1 manual to determine if the presumption of soundness applies, right? Step one, they review entrance medical exams. At the time of entry, like I was talking about, if your medical records show no pre-existing conditions, the presumption begins. For example, if your entrance exam does not list a ankle problem, the VA cannot automatically assume any later ankle issues were pre-existing. That's very important to know. Step two is seeking clear and unmistakable evidence. The VA must show clear and unmistakable evidence that the condition was not aggravated by service. For example, it didn't worsen because of your service and or it existed before your time in service. The VA must show clear and unmistakable evidence that that condition, right, existed before your time in service and was not aggravated by service. Number three is determining if a condition manifested itself during service. So if you were diagnosed with a condition during active duty that wasn't noted on your insurance exam, the VA should presume the condition is service connected unless the VA can prove otherwise, right? So if you were diagnosed with a condition during active duty that was not noted upon MEPS or your entrance exam, the VA should presume the condition is service connected unless the VA can prove otherwise. And again, if they deny you, then you need a nexus letter, you need more up-to-date evidence. Just come with additional evidence and you should be able to get it and establish service connection. So the presumption of sound doctrine or soundness is incredibly beneficial to you, to veterans, to us, especially in complex claims where the origin of a condition is in question. So I want to give two examples, right? Here's a couple of examples of how it plays out in correlation to disability claims, right? No documented pre-service condition. So imagine that you're diagnosed with PTSD during your service, but there's no prior record or diagnosis before enlistment, okay? With the presumption of soundness, the VA must assume that PTSD was caused by or aggravated by your service or in-service stressor unless they can conclusively prove it existed before and was not worsened by service. Okay, so that's why when you're talking to the VA, when you're articulating things, you need to keep everything on what happened in service while you were in service, right? Number two is documented pre-service condition with aggravation. Let's say you had PTSD before service and this was documented during your entrance exam. If your condition worsened significantly during your service, your PTSD, the VA cannot automatically deny you benefits by claiming it was pre-existing. The VA, has a burden of proof. They also must prove without a doubt that your time in service did not make it worse. If they fail to provide this clear evidence, they must treat the aggravation as service connected. So, what is the benefit? How can you, the veteran or military service member, if you're transitioning out, how can you leverage the presumption of soundness in your claims, right? Leveraging the presumption of soundness means keeping a few of these key strategies in mind. Provide evidence of aggravation. If you have a pre-existing condition that worsened due to service, gather your medical evidence. Keep getting the treatment that you need, demonstrating the aggravation. Statements from private doctors can really help boost your claim, boost your case, especially if they can link nexus the worsening condition to specific events or exposures, right? Obtaining your entrance and service medical records, your entrance medical exam and any service treatment records are absolutely critical and crucial. If your entrance records do not mention the condition, you have a strong basis to invoke the presumption of soundness and, if need be, request a nexus letter. Look in the description of this video. There are honest, integral doctors that I can point you to that are going to research your medical records thoroughly. And if they cannot write a nexus letter, they're not going to do it. But if they can, they will write a proper nexus letter for you. So make sure that you request a nexus letter if you need one. A nexus letter from a qualified private healthcare professional, board certified, can strengthen your claim. This letter should clearly connect your condition to your military service, countering any attempt by the VA to claim it was pre-existing without service impact. So in a nexus letter, there's medical and scientific literature that connects problem A to B. So let's say you get chronic fatigue due to your PTSD. I'll use that for an example. Those can be connected. There's some evidence that you need with that claim, but the doctor should be able to prove with medical sources and scientific literature how PTSD aggravates and impacts chronic fatigue and causes tiredness and lack of sleep and all that. But you, the veteran, must have complaints in your record as well too. So a nexus letter from a qualified private healthcare professional should help your claim, right? And should really counter any attempt by the VA to claim it was pre-existing without service impact, right? If you're appealing a decision, so higher level review or supplemental claim based on presumption of soundness errors, right? If the VA improperly denies your claim based on the presumption of soundness, you have options to appeal. Last option is always going to be the BVA, the Board of Veterans Appeals, because it's going to take a long time, right? If you know that you have if there was a clear and unmistakable error, you need to do a higher level review. This is the option to have a senior VA adjudicator review the claim. This level of review does not allow for new evidence, but can correct Q errors, clear and unmistakable errors, or duty to assist errors. And then you can file a supplemental claim on a 0995 form, which means that you add new and relevant evidence, meaning it was not included in the claim that was originally submitted for whatever condition you were filing for. If the VA provides insufficient evidence that your condition was pre-existing or not aggravated by service, you can file a supplemental claim with additional evidence or a stronger nexus letter. It's very important to know that. So to wrap things up, the presumption of soundness is very powerful. It's to your benefit, veterans, military members. If you're transitioning, if you're about to file your VA claim, it's powerful protections that us as veterans have in the VA disability claims process. It levels the playing field by placing the burden of proof on the VA, ensuring that veterans are given the benefit of the doubt understanding how to leverage this presumption is absolutely critical, especially when dealing with complex conditions or pre-existing issues. This can make a tremendous impact and huge difference in your claim's success, right? So if you're struggling or you need a nexus letter, look in the description of this video. Dr. Sharma, Dr. Lopez, if you need some musculoskeletal letters, nexus letters, we can put you in the right path, and they're going to check all of the proof that you have, all your medical records, to absolutely make sure that they can write that nexus letter before charging you a dime. Okay. So it is very, very important. So again, we went over, just to reiterate, the legal foundation, 38 CFR, VA's burden of proof, application and disability claims, and protection that you have as veterans. I hope that this video helps you. I hope that this puts you in a better position than where you are. We want you to know that you matter, that you are very, very, very important, and that your claims do matter. File for what you can get the help that you need, stay in the best position, stay educated in everything that you do. Make sure that you get the help that you need. Don't file up, just throw something up there, just assuming that you're just going to get it, because that is not how VA disability works. It's just, you aren't going to just automatically get it. You need to make sure that you have that proof. In treatment is super, super important, veterans. It's very important. Joe Black said, but they don't assume that, brother. I'm getting an IMO and a nexus letter from Dr. Sharma. I had to take my case to a board judge, and she ripped them a new one. Still took years.